So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about a new memorandum between the U.S. Equal Employment Opportunity Commission and the U.S. Department of Labor Wage and Hour Division. And this new memorandum of understanding MOU really changes everything that we think we've seen with respect to enforcement of the labor laws in the United States. It makes the federal government's job a little bit easier. So let's get into it. Let's talk about it. So the new memorandum of understanding establishes a working relationship between the DOL and the EEOC. In their words, they're looking to establish a collaborative relationship to enhance and maximize the enforcement of federal laws administered between the two agencies. They're forming the partnership to encourage greater coordination between them through information sharing, joint investigations, training, and outreach. And ultimately, let's be clear here, what this is about is having those discussions between the two agencies when people are violating the law. Quite frequently, when they're violating one employment law, with respect to the payment of individuals or the enforcement of the Services Contract Act or any number of various employment laws in the United States, they're often violating other laws that are outside of the agency's purview. So here they establish the purpose of it, which is to maximize and improve the enforcement of the federal laws administered by the DOL and EEOC. It should encourage and enhance law enforcement and greater coordination. And ultimately, what that means is that bad businesses should get both situations coming down on them, right? Both the EEOC and the DOL. And quite frankly, this combination should have been happening a long time ago. Just as a quick overview, the Wage and Hour Division is authorized to administer and enforce the Fair Labor Standards Act, the Davis-Bacon Act, the Services Contract Act, the Walsh-Healy, Immigration, Nationality, Polygraph Protection, and establishes federal standards for wage and hour of work. And the Equal Employment Opportunity Commission enforces federal equal employment opportunity laws that prohibit employment discrimination against applicants, employees, and former employees. This might include complaint referrals. So, for example, one complaint may be made to the DOL or the EEOC, and if that complaint isn't within the agency's purview, the agency will still inform the complainant to move their case to that area. They'll also be sharing case files, which seem to be really important, especially for this work. Both the DOL and the EEOC rely on heavy levels of data to inform their decisions and to inform some of their enforcements. And as a result, using that data within each other's departments is probably best practice. The other thing that will change is that the agencies could determine to conduct a coordinated investigation when matters arise between both agencies' jurisdictions. If the agency decides to conduct coordinated investigations and the Wage and Hour Division finds a violation and the EEOC finds a reasonable cause, they can explore whether or not it's appropriate for one agency to settle or conciliate its matter while the other one holds the matter in abeyance. So in addition, when it is functional and important, they're going to train each other's staff on identifying cases and issues that may arise and under the other's jurisdiction. So they're training their staff to recognize and functionally create more cases for them, and creating more work for each department if they see things that need to be enforced, if they see measures that need to be enforced. There's, of course, a lot around confidential information and information security, as well as resource provisions. They're not going to get any extra money out of this. They're just simply, each are responsible for funding efforts to fulfill their respective roles. And there is no, exchange of money in this scenario. Let me know what you think in the comments down below, right? I mean, this to me seems to be a long time coming. The Wage and Hour Division and all branches of the government should bring rule violators to the, to judgment. I think that this could cause a lot of problems for a lot of employers because, again, bad employers are often bad in many different ways, not just, not just from labor violations, not just from EEOC violations, but generally speaking, they have poorly informed HR departments that are not advising or don't exist. They're companies of appropriate risk, and as a result, they're failing their people and their companies. Like I said, let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.